On page 19, it's Oren Alexander. And on page 20, it's Alon Alexander. If you all want to announce your names for the record, please.
Natalie Snyder and Laura Penn on behalf of the state.
Good morning, Your Honor. Ed O'Donnell on behalf of Oren Alexander.
Good morning, Your Honor. Joel Venero, Alon and Alon Alexander. How are you?
Good, how are you?
Good to see you.
Same to both sides. So I have these cases on for status. If you all want to update me, feel free to do so. I'm just going to go under the impression that their trial is still scheduled for the new year in federal court in New York.
That is my understanding, Judge. At this point in the cases, we have, I think, just about every deposition set that the defense wants set over the next couple of months, starting on Monday. And I think that's our status at this point.
And regarding the motion to compel, I know you all stepped out a little bit.
We did, Judge.
While we're discussing this.
We were discussing this, Judge. We have provided some photos off of the iCloud. We provided everything that we think is relevant at this point that we've seen. And Judge, I think the state asked you to deny the motion to compel at this point. I think it's a very broad request.
All right, defense.
Yes, good. Yes, Your Honor. On the matter of the iCloud of SM, so the iCloud was a warrant from the lead detective in this case. And the warrant was from.
Let me do this, Ray. Do you have the motion? It was 9-5. No, I have it. Do you have the state's response? Filed 9-10.
I filed it yesterday.
You have
a copy. We need to.
It's
No, I have it. I just didn't know if it was redacted in the clerk's copy, the cell phone number.
Judge,
There's a cell phone number, right? On
that is,
paragraph
yes, that
4.
is a defendant's cell phone number that was the target of the warrant. So I believe it's in the warrant, Judge. So if we need to redact it, we're going to have to redact it.
Well, you all tell me if you wanted to redact. I just wanted to bring it to your attention because sometimes things.
Yeah. So Judge, I'll leave that to defense as to whether they want that redacted or not. I think it's already in the record. It is the defendant's cell phone. It was the target of the warrant.
Same thing with the, what about the email address? In the affidavit for the search warrant?
Yes, I think that, I mean, that affidavit is all part of the record already.
Right, but did you want that email address redacted?
Oh, we can redact it. Yes.
So
Yes.
when we're done, you can take my,
Okay.
my copy of the state's response, make whatever redactions you think are appropriate, give it to the clerk, and then they can hopefully accommodate you upstairs with whatever's already been filed, okay?
Okay.
All right, so let me just ask the state real quick. In your response, you're saying that whatever you did receive from that iCloud warrant, you've already reviewed and turned over what is discoverable to the state. I mean, to the defense.
Yeah, Judge, we've searched it. Detective Timmeros has searched it. Ms. Penn has searched it. And from our search, we've turned over everything that we have found that is relevant to the case. I don't see anything exculpatory at this point. But we turned it over.
All right, so that's their response. Why are you entitled to anything more?
All right, Your Honor, first I'd like to start with the timing of our receipt of any discovery, because I think the state has not complied with discovery specifically in this situation, but beyond not complying to the point where I think it should be a concern to the court and to everybody, everybody that it's the rules of discovery have been ignored by Ms. Snyder on this case. And whether it's intentional or not, I don't know, but a iCloud warrant was sought by the lead detective before Mr. Alexander was arrested. Remember, SM came in 7 years later after an arranged personal phone call with Kathy Fernandez-Rundle and Natalie Snyder with the family, and arranged for SM to go meet with Detective Pascal. Detective Pascal was picked to be the lead detective. SM, after 7 years, from her recollection of what occurred on the night she slept over naked in his apartment.
I could appreciate that if we were set for trial, these delays may have hindered your preparation, but at this point going forward,
I-
what's the prejudice?
Well, the prejudice-
Listen, I see the 5 or 6 month delay.
No, a
I see
year
it. Okay,
delay, Your Honor.
sorry, the
9
year
months.
delay.
Okay. I think it needs to be on the record because we
It's
believe,
in the record, it's in your motion.
Your Honor.
We're not gonna go on talking about naked this and naked that.
Okay, that's fine, Your Honor. But
Timeline.
That's why it's so important, Your Honor. We're talking about a recollection that 7 years previous was a date with SM and our client. Okay. And a subsequent date and subsequent weeks of communications before the date, weeks of communications after the date where this allegation of a sexual assault / rape occurred. Not only communications, but communications, Your Honor, that had to do with arranging and setting up their little dating period that they had, even post allegation.
When is she set for deposition?
Monday.
Monday, Your Honor. So there is a prejudice, but there's a prejudice even if the trial was set 5 years out. The rules of discovery say within 15 days of receipt, we are supposed to receive things. So, Your Honor, I think it's incumbent that we bring this up on behalf of our clients. Okay.
And
Because-
if you were prejudiced because of the delay and you wanted to push back the deposition date, I could see that as a remedy. And you wanted to bring it to my attention to show me that you're not the one delaying this. I get that, but that's what I'm thinking. What else are you prejudiced?
I'm asking that after you hear the timeframes and the significance, and still to this moment, as we're here, as to how there's been non-compliance, we're going to ask for remedies, and we're going to ask the court to instruct Ms. Snyder and Ms. Penn to start complying with the rules of discovery, and that this isn't a game that they get to choose the rules on. The rules are set, and there's a reason. Like, for instance, the Duke Lacrosse notorious investigation where a prosecutor was not handing over information that was important, if it not had been for a whistleblower that came forward and said, look, the state's aware of all this evidence. They just haven't handed it to you. Fortunately for us, we on our own, through some dumb luck investigation in Chapter 119s, have discovered there is crucial information out there that we have not been provided. And we haven't been provided it to this moment, and it's been ignored. And I don't think we can just say, well, they can hand over discovery a year later to us after they see fit. So, Your Honor, on October 15th, on October 24th of
So what is it that you want me to do? How do you want me to help you prepare? If you're saying that they're turning over discovery late and it's affecting your preparation.
So we're still not prepared, because here's why, Your Honor. We don't have what we need. On October 24th, subsequent to Detective October 24th of 24. So almost a year ago, Detective Pasquale, based on what SM, the alleged victim after 7 years claimed happened to her, decided she needed to get an iCloud warrant for SM's phone, because SM claimed she didn't have any of these messages about them setting dates up, about them posting, and most importantly, SM told the detective in no uncertain terms that I was threatened by messages sent to me in a chat with Oren Alexander, and SM's sister also said, oh yeah, she sent me those. I saw those. They were threatening in some way. I don't have them either. So the lead detective back on October 24th of 24 seeks an iCloud warrant to get the threats and the communications between them. Why? Because she was going to use it as evidence against them and presumably charge our client with threatening this person. Ms. Snyder personally oversaw the warrant, approved it. It was sent to iCloud, Apple, and it was received on November 25th of 24.
So what is it that you want me to do?
Well, first I need the facts to be
They're in your motion. What do you
Well,
want me to do?
well-
Remember, it wasn't noticed for today. I'm happy to accommodate,
Well, you're,
but you saw Mr. LeVay behind you, right? I'm supposed to take a plea in his case.
no,
So
no.
at some
I-
point, I need to take a plea on Mr. LeVay's
Your Honor, I'll
client.
be glad to wait. The only reason we're arguing it now is because your JA told us you were going to hear it today.
Yes, I am going
So,
to today.
yeah, we filed it. So on November 25th of 24, Your Honor, the state of Florida has been in possession of SM's iCloud ever since then. They never told us that they had an iCloud. After they received the iCloud, it was still before the arrest of Oren Alexander and the Alexander brothers. They had the opportunity to review it. They had the opportunity to see that what was in that iCloud, and if anything SM allegedly said was true. As we sit here today, nothing that SM told the detective was borne out. There are no threats. There are no communications where she was threatened in any fashion. Yet that was not disclosed to us. Despite that, they arrested the Alexander brothers on December 11th of 24. Okay. Despite the fact that for 3 weeks, they had information that presumably contradicts what their victim said happened 7 years ago. Okay. So now, we were never told of the existence of even a warrant. The rules of discovery require they provide information to us that there is a search and seizure, that there's a warrant, that there's discovery. We're going to look for it. Nothing, never disclosed. We did a Chapter 119, Your Honor, and we discovered in Chapter 119 this warrant. And it was only after we ourselves saw this warrant on our own that was never, and I believe would never have been disclosed to us. Okay. Now, several months later, the warrant is turned over to us. That was on April 9th of 25. So they've had the warrant since, as Your Honor is aware, the return on the warrant since November of 24, the end of November of 24. So we get the warrant, just the warrant in the affidavit, finally on April 9th. We asked several times on the record through different hearings. As Your Honor's aware, we were concentrating on one particular case. Ms. Snyder said she would get us the information. We never received anything. On July 14th of 25, so 8 months later, this is what we received. I'm going to hand this up. This is all we received in this exact format. I'd like to put this on the record.
I think it's attached to your motion.
It is, Your Honor.
It's the last page.
This is
Tap, right?
Your Honor, this is how it was provided. Impossible
from the-
to see. Even if
That's from the WhatsApp with another individual named Oren. That was the result of the search.
Another Oren.
And it's another, because they searched for the term Oren. The phone number came up with nothing. They searched for the name, and that's what came up under Oren. It's a female that the victim knows. So it's just, there's nothing there, Judge. I mean, that's.
Right. Your Honor, this is what was turned over to us. And forget the content of it, whether it's significant or not. I still to this day can't read it. It was turned over in a font that is.
Let me ask you this. Can you give him a better copy of it?
Judge, that's how the report prints it.
That's what you have.
I can ask. Yes, probably we could try to do something.
Okay, they're gonna try to get you a better copy.
That's not so small fonts, but.
So we've been able to determine now with a with a magnifying glass, there's about 1/8 of a page of entries. They have absolutely nothing to do with our client. Nothing. Zero from the iCloud. On July 28th of 25, myself, I was in Greece, Your Honor. I cleared the deck. I was 7 hours ahead of everybody else. No big deal. We'll take the call to discuss this return that we received showing us nothing. I was in Greece. I waited up all night to have this conversation. The state tried to cancel it. I said, look, I can't do it tomorrow. I stayed up for this. So they made the arrangements to have this important call. Mr. De Niro, Ms. Snyder, and Ms. Penn and I had a call. It didn't go very far when Ms. Snyder said to us about what she had given to us is that's all there is. That's all you're getting. There is nothing else that is relevant. Take it up with the court if you like. That's it. I reviewed it and I determined what's relevant, and this is what's relevant. Okay. We now know that this is some girl named Oren with a different last name that SM is friends with. That's what we were provided. So that was on July 28th of 25. We had to file a motion to compel the iCloud. So yesterday, throughout the afternoon yesterday, we started receiving trickled discovery responses. We received a photograph from the iCloud of one photograph from the iCloud that shows SM, our client, and someone else. I believe it's on October 20th of 17.
19,
Of 19, pardon me.
before the incident.
That's the night of the alleged sexual assault. They're on a date. That was never turned over to us before. It was turned over to us with zero explanation.
Is that from the warrant or something else?
Judge, we did when we went through and looked at so the initial, I never told them that was all that was relevant. That's all that came as a result of the search is what I said, because we were searching again for that number. We were searching for messages. That's what we were searching for. We went through her photo library. And from the date, that was the only relevant photo.
So that photograph is not from the search warrant from my.
It is from the search. It's from the iCloud search warrant of her.
Okay.
iCloud. It is from World Red Eye, Judge. It's a photo from earlier in the night prior to the rape. I don't know if you know the facts of this particular case, but she does go with him to a real estate event that night. So that is a photo from that real estate event, again, prior to the rape.
But you said you went through her photo library.
It's in her photo gallery, which has thousands and thousands and thousands.
Right, but it's from the photo gallery from the search warrant?
Yes.
Or she says, here's my phone, go through the photos?
No, it's from the search warrant.
All right, because this was in the iCloud.
It was in the iCloud.
Okay. And you turned that over to them?
I have turned it over now, Judge. Yes.
Yesterday.
So what's your ask of me?
Okay. So,
Big for the request.
well,
As I suggested, if you wanted more time to prepare, put them on notice if you need more time to go over this photograph and anything else that you recently received from the from her
okay.
because her deposition is scheduled for Monday.
Yeah, Monday. Your Honor, so I think there are further facts before we can get to the many things or the couple of things we're going to ask for. Now, we received a few other photographs, unexplained, didn't tell us where that was from. I mean, we were able to figure it out. We still don't know, other than this was on the iCloud of SM and never provided to us, never provided to the state by SM, and more importantly, never provided to us. We received a few more pictures and videos yesterday, just yesterday. After, remember, in July, we were told there's nothing else and you're not getting anything else, whether you like it or not, because Ms. Snyder decides what is relevant and what is not relevant. And we received some photographs. We just happened to figure out what they were, but they wasn't explained to us by the state. There's somebody windsurfing or kite surfing off a beach. And there are several photographs and there are videos. And that person happens to be Oren Alexander. And he's kite surfing. And the significance is the person that took those photographs and took those videos are SM. And they are weeks. They are weeks after the date of the alleged assault. She is on a date, photographing it, videoing our client on a beach date. Weeks after the allegation that she said she had non-consensual sex with our client 7 years later.
This is what the clerk just handed, right? Pictures of the parasailing,
Yes, there are, but there are videos.
pictures and videos of the parasailing.
Yes, pictures and videos of SM, the alleged victim in this case.
And these are also from her.
Those are from the iCloud, Judge. The state, I understand defense has a different version of facts, but you may recall from the statement that the victim gave, Judge, she says that she goes to confront him on November 3rd. She meets him. He's out kite surfing with friends. I believe Alon is also there, Alon Alexander. I'm not sure if the person in the kite surfing, you can't really tell if it's Oren or Alon. But she does have, from that day, she does have a couple of photos and videos of the
And
kite.
this was recently turned over as well.
Yesterday.
Photograph.
Yes, it's been
the,
turned over.
It was turned over yesterday, Your Honor.
What else?
So we believe just in the few photographs we were given yesterday, based on technology, we obviously need an expert to look at the metadata from the phone, but we believe there are several photographs missing in between all those. So we need to see the phone for that, clearly that period, but and other periods. So it's Brady.
They're saying it's from the iCloud, not the phone.
Well, it was taken by the phone.
Oh.
Right. It's the warrant. It's the warrant,
For the iCloud.
the iCloud, and the iCloud is SM's. And
I think we've all learned over the last year, what's in the iCloud is not necessarily on the phone.
Yeah.
Correct.
Yeah. Put two and two together, supposedly she's on a beach and she's videoing with her phone. And from her phone, they go to the iCloud, I can't say it now, she's out there with the camcorder, but we're just, by reason, just deducing that.
It's reasonable to believe she took the video from her phone and then stored it in the iCloud. But what this,
There's just not stuff going on. There's gaps where there shouldn't be gaps. So I don't know what the state sort of process is.
look, I think I know where you're going with this. Look, I think I know where you're going with this. At this stage, they've turned over the discovery. If you want to go into her phone, you have to file a motion, put her on notice, because I think we know that she would have the right to object. So my suggestion is draft your motion for inspection, for physical inspection of her phone, because you may want things such as the metadata, et cetera. So is this where we're going? Is that the ask?
that's one piece, Your Honor. But we do not believe, and we know we have not been turned over the discovery. Okay. Just because they handed over a few people, remember on July 28th, they told us all that existed was an Oren female. That has nothing to do.
She is represented by counsel, right?
She does, Marcus.
I saw that
Beaton,
name. I
Yes.
saw that name somewhere in one of the motions, right?
And-
Have you all spoken to him about
No, Your
having
Honor.
her turn over the
He
phone?
wasn't representing her until probably April, several months after the return of the iCloud. So what is missing from those photographs we are entitled to? One, this is Brady, an accuser who makes a 7-year later allegation of non-consent, which is the issue, has photographs in her iCloud showing her on a date and filming the perpetrator, in her words, is Brady. 3 weeks subsequent to when she claims 7 years later that she was raped. So that's Brady, and it's very concerning that it hasn't been handed over. And we believe there are other photographs and videos, because just based on the numbers that were provided in these.
It's like you have dates, right? Dates where these photographs were taken. I'm looking at October 19th, 2017 of the one from World Red Eye. And I think there's dates from the parasailing beach.
It's 11/3.
Right.
2017.
So I can see that if you drafted a motion to compel or a motion to inspect her phone, gave it to her lawyer, maybe you all can resolve it among the lawyers. If not, then you can ask me. But right now, based on the way that your motion is drafted and based on their response, I can't let you go into her phone.
Okay, well, here's what else is missing, Your Honor. Not one message coordinating the dates, about the dates, subsequent to the dates, arranging the beach date after the alleged sexual assault. all their communications. None of that has been provided to us.
And we don't have it, Judge. I mean, we've been through correct, we don't have, those are not on the iCloud. So again, they're going to depose her, and I'm sure they're going to ask questions about all of these things and how this was done and where these were made. And then if there's anything that exists,
Would you be willing to ask her if she has them, if she can just look through her phone?
my understanding is a lot of them are on Instagram DMs, which she tried to pull. She wants these. I'm going to tell you right now, she wants us to have these. That's one of the reasons we did the iCloud warrant to begin with, was because she was asking us, because there are threatening messages that, you know, she said that she at some point deleted. So
But are you-
so she is actively, she wants to give these things to us. She's just having, because it is older, she's having problems finding them. So she was going to try something else as far as through Instagram to see if she can recover some of the messages. I don't know if that's going to be successful or not. But, you know, we did learn that that is a possibility of something that you can do. So she's going to do that.
What about in their motion, they reference something called artifacts. We didn't get any artifacts.
That was the WhatsApp, the artifacts. I mean, that's what the examiner.
So hold on, so we could speed this along.
Yeah.
Are you in a position to have a conversation with her and her lawyer, because she's represented, about whether or not there's anything physical in her phone? In other
We've already
words,
had that conversation.
and there isn't.
This is all we've received, and
You-
she says she can't find anything else.
All right, you've made the ask. She's either searched or she's looking.
Or she's looking. I mean, she still is actively searching for these things.
Okay.
Should be at least entitled, October 17th to the end of the year. We're not asking for 4 terabytes of information. But based on the fact that there's clearly missing photographs and missing videos from that time. If we could just isolate, I think reasonably, that's what you're outside talking about. I think this should be between the defense and the state. Bring in victims, sort of attorneys, and start talking about the state did
Right, but-
rights.
Yeah, but if you,
He does have rights, Judge. He
He
does have
already
privacy
knows.
right.
listen, I fully understand the due process rights of the defendants. But since we've already been down this road before with Mr. Fisherman, I think I know you all are gonna ask to inspect the phone. We know that the victims have a right to be heard. So since we know SM has a lawyer, draft your request, send it to the lawyer. If you all can't resolve it, then come back to me, because what they want is to inspect her phone.
And I understand that, Judge, and we told them outside that if they want to give us a specific date range, we will speak to the lawyer, we will consider it. But that's not the request that was made here. They wanted the entirety of the iCloud.
No, we didn't, Your Honor. We
That's what
want
it
what's
asked-
relevant.
Well,
And Brady, and I'm going to get to further things that are Brady and it's,
I'm still waiting.
okay.
as far as Brady, he keeps throwing around this word. It's speculative at this point. There is no Brady. You know, he hasn't given anything that is Brady, just because she has other photos between, October 19th when this happened and November 3rd. Yes, she does have other photos in there that are completely irrelevant to this case. They're not necessarily entitled to that.
Well, we don't need to rely on what Ms. Snyder thinks is relevant. So for instance, the morning SM woke up after their date at Oren Alexander's apartment, where are the communications? Where are any photographs, whether it's of a dog? Where that is relevant. We've already been through this, as Your Honor said. You believe that would be relevant for us to see certain timeframes of what was communicated.
My suggestion is put it in writing, show it to the state, show it to her lawyer, and if you all can't agree on it, on either her inspecting her phone, you inspecting her phone, or her going in and looking for dates that you suggest, you can put it in front of me, okay?
That's fine.
So for now, your motion to compel discovery is denied because the state has complied, right? This one is denied, the state has complied. The response, I tabbed it, parts where Mr. Alexander's phone probably should be redacted as well as SM's email, right? If you all can agree to redact those.
Yes, I can do
I think
that.
that's probably the best way, because they were, I think most of the emails were redacted in their filing.
Okay.
All right.
Yes, I can.
What should be our next check-in date?
Judge, I think, again, we have the depot set. I think another 60 to 90 day status. And
Is
if there's any
December-
other issues, they can bring it up.
Is December okay? between
First that,
counsel.
yes, Your Honor, that's fine.
Yeah.
Your Honor, there are a couple more matters that, and facts that I think the court needs to know as to why we know we haven't been provided anything that still exists. One, clearly, let's see when and how they were erased. We're entitled to that. If you want us to do that in a separate motion, be glad to do it. But,
No, the state has that answer.
I don't have it.
uh,
They would have to ask her, Judge.
Yeah.
but the state has when this SM called in and said, hey, I've been sexually assaulted, they had full access to her, carte blanche, white glove, setting up special meetings for her. But now for the next year, they don't have access to her. They can't talk to her. They have a duty and an obligation to ask their victim to get us this information. So, for instance, how do we know they have it? Ms. Snyder in her response says, there are artifacts or remnants of communications between Oren Alexander and SM, but we can't access them. So you know what Ms. Snyder thinks she's going to do? She thinks she's going to go at trial and say, SM's telling the truth. She does have communications with them. They're just gone, right? She puts it right in her response, Ms. Snyder does.
Judge,
Please don't interrupt me. They're just gone. So she's going to argue to the jury that they're just gone because they're so old, but they exist. Just not the verbiage.
So she'll make that argument to the jury, right? That reasonable inference of
She
them not
claims,
existing.
yeah, she claims in her response, her two-page response, that there are artifacts to try to support that SM is not lying
with
about
a
these
different
threats.
Oren, Judge, with a different Oren. I don't know if.
In her response, she says there are remnants of communication.
Forward with a different Oren.
Okay, so now she's saying on the record, there are no remnants of any communications whatsoever between Oren Alexander and SM. They just completely wiped out. In our motion, we will request, show us how and when these were erased. For instance, were they erased once SM knew that there was a warrant being, when?
My suggestion is have her provide an affidavit. She can answer you.
I mean,
or ask her in
SM provide an
deposition.
affidavit?
Closed on Monday, so they can ask her.
Or in the
And
deposition.
Yeah, yes, Your Honor. So here are some, that's for the past 7 years, that now we just have, I can't believe a prosecutorial body wants to rely on someone's word from 7 years ago, and it's been proven to be unsubstantiated. So now let's get to the fact that the warrant was issued before Oren Alexander's arrest. And we know for a fact from chapter 119 that was never disclosed to us by Ms. Snyder that SM and her husband had full-blown phone conversations, text communications, email communications with Ms. Snyder, maybe Ms. Penn, we're unsure of that, and Ms. Rundle. Those are encompassed in the time frame that the warrant was issued. They haven't handed over any of those communications. Clearly, they are discussing the facts of this allegation from 7 years ago. This isn't 7-year-old information. This is right before the arrest, Your Honor.
Did they give you a time frame of when they're going to comply with the chapter 119 request?
No, we only know that those exist.
And you're waiting for them to be disclosed?
No, they have not disclosed it in the iCloud. Those messages absolutely would be in the iCloud. They can't say, oh, 7 years ago, they're gone. We don't know. Poof. They're just.
Yeah, but haven't we learned if someone doesn't choose text messages or iMessages to back up in the iCloud, that they're not backed up? You have to choose that. What's the right word for it? That setting, right? You can go in. Yeah. So.
You could sure
Right.
Right.
And they're on.
They could be on the phone if you delete them. But remember too, some people have auto delete, right? It's a setting. You don't know what her setting is.
Well, they have 8,000. Wait a minute. How many?
But hold on, but you did a chapter 119 for both sides, right? Of the text messages from the state attorney's side as well as from her side, right?
We can't do it from her side. So, you know,
From whose side?
Was it?
SM side.
we can't get them from SM because it's not
Okay.
a public. So, Your Honor, we only got bits and pieces and we know they've been edited. We've read.
Edited?
The-
Judge,
yes.
I'm sorry, but I've given all of my text messages. I know that.
Not. Yeah, we have 7 questions in a row.
I take offense to that.
We have 7 questions in a row from Ms. Snyder between her and Kathy Rundle about the facts of this case, and every answer from Ms. Rundle is erased. I believe that sequence it went.
In their response,
The state attorney.
No, but we do not have all the communication.
Without-
That's what I'm saying.
Yeah.
look,
That
wait,
text message with no
yeah, but
answers.
the messages between SM and our state attorney, that issue's not in front of me, right? You did the chapter 119.
It is because it's proof that there were communications about this case.
It's not in the motion to compel that I just ruled on.
It is though, because I'm telling you, that is how we know there are communications in the iCloud presumably that we need to see as to why the messages between Kathy Rundle, Natalie Snyder, the M family, are not encompassed in the iCloud. Yes, Your Honor gave the one way it could innocently be. She has it on auto delete. But you know what? I think Ms. Snyder has said here on the record that there are thousands and thousands and thousands of communications and data on this iCloud. So it clearly wasn't on erase. It was not. It's just Ms. Snyder has chosen what to turn over. And I don't want to go back to it, but this in July, Ms. Snyder said this is all there is that's relevant. And I want to further go back, Your Honor, in
The remedy you want, I may be able to give it to you if you want to go into SM's phone.
Yes.
Okay, physically, but you have to put it in writing.
Yes.
And my suggestion is give her and her lawyer notice first. Otherwise, you're gonna file it. If I grant it, you're gonna serve the subpoena on her and we're gonna be right back here, right? So my suggestion is, because we've been down this road before with the other case, we sort of know what's coming. So that you all don't waste your time, please do it in the manner that I suggest.
Absolutely, Your Honor. And in the warrant, we know that the state has had in their possession the return from iCloud for, I don't want to misstate, but a year almost a year. They know, they can see if there was auto delete turned on.
I don't know why they say if auto, I don't think I can.
They can.
I think it's
They-
whether something got deleted on the phone versus in the
If you
iCloud.
wanna
I
ask
can't
her-
say that I can't.
If you want to ask her about her settings, ask her on Monday.
Yes.
But I don't need to take her word for it. The state has an iCloud warrant they received. They know the answer to that.
I don't know that. They can,
I
they
don't
can,
know that I don't think I do know that, Judge. I think.
I mean,
that's
I,
something on
I,
the
I
phone.
would suggest they ask the Miami Beach detective that reviewed this. And if he can tell, I don't think that's an unreasonable ask, okay?
Is that
They're gonna ask,
one of the remedy? The state is going to ask.
we all are having a conversation. I'm not ordering anything. I'm not ordering
Well,
anything.
what-
We're having a conversation.
You see what happens? The state has taken things like that to mean they don't have to comply with the rules of discovery.
You have
So
to-
why is she going to give it?
You have to be more specific in your demand. Your
Okay.
demand is not specific.
Okay, the rules of discovery say they have to hand over relevant information. They received it pre-arrest of Oren Alexander. We're here on September 11th, almost a year later, and they haven't handed us anything over other than a few pictures. We don't have to go and take a shovel and start digging.
But what
We
is
just
their,
turn it over.
what is their response? We've searched, reviewed, and this is what we are turning over under the rule. Under our obligation, this is what we're turning over. How else am I supposed to dig further than that?
I think you tell the state they have discovery obligations that they need to comply with within 15 days. 15 days, and we received something almost a year later, Your Honor. Okay, how was that complying with the rules of discovery? Rating.
I'm not saying or suggesting that the date that they turned these over to you is within a reasonable time frame. I'm not saying that. They probably should have done it earlier. Okay, I agree with you on that. But you're not telling me that you're ready for trial tomorrow. Your client's not even available, right? So, you want to prepare it as efficiently as you can. I'm giving you the time. I haven't issued arrest warrants for them, and I would be within my right to do so. But you're working on it diligently. There is a public policy to have these cases resolved sooner rather than later for both sides, whether it's the defendant and their family or the listed victims. So they're having parallel prosecutions between the state and the federal government, I think benefits both sides at this point. So we're gonna chug along, okay? So
Yes, sir.
the suggested court date for us to meet next, unless you file motions to compel, and you need my intervention, is going to be December 4th at 10 a.m. December 4th at 10 a.m. That's a Thursday.
Obviously, if you think do exist, they don't exist, I think we can establish there that they would be material. Text messages, between her sisters, text messages.
I think it could go, I think it probably goes to bias or impeachment, yeah.
Because. So we're asking for material, they can rule requires on page 12 of our motion that they do a privilege law, and we kind of see.
It's not a privilege, Judge. There's no privilege here. He doesn't have any of her messages backed up to the iCloud.
It's what we see. There's things that they're leaving out, these and why, and everything.
Oh, you mean their internal notes?
Yeah, but we're entitled to see the rationale. This is illegal. We had a process, we used, our process was we searched the name warrant.
This is a 4 terabyte item.
Just looking for breaking information or materials, there would be a lot of other words that I would use to search for, so I think.
Judge, if they want to provide search terms, we'd be happy to go through and run it with those search terms. I mean,
We don't need years.
You're going to have to be more specific. Look, I want to help you, but you all have to be more specific. Yeah,
I can come up, I would say.
because what they did is you ran it for years, right?
I'm sorry?
The iCloud warrant.
Yeah, it's years. It
Years.
covers years and
So
years and years.
it wasn't just this 2017 window.
Right.
We just want months, so.
Again, if they want to get us specifically what they're asking for, narrow it, because that wasn't in their motion. We will speak to Mr. Beaton. We'll see if they have any objection and we'll discuss it and decide if we have any objection.
Okay, so it sounds like I'm going to see you all before December 4th. Feel free to contact Chambers for an earlier date for the motion, okay?
Yes, Your Honor, and just so we're clear, it was the state, Ms. Snyder and Detective Pasqua, who decided they wanted to see, and they put specific dates in their warrant, from December 17th up till the very day. They wanted everything to the very day of the warrant return. And that's what they got, presumably, but we're not able to see.
Thank you all.
Oh, Your Honor.
Yeah, last thing real quick before I bring in Mr. LeVay.
Sorry. So, Your Honor, we have to digest, because we're obviously not technologically,
Savvy.
well, even if we were, right, there's a lot to digest with just these few photographs that were clearly Brady that were handed over. So we need to speak to our client and some people that understand the technology that was provided to us. And we may want to reset the depositions based
Just
on.
give them notice.
You just need to tell us.
Yeah.
Right now.
Okay, I just wanted to bring that up.
Next week,
Well-
we have 2 witnesses set next week.
We'll let
SM and her husband, so they just need to let us know.
we'll let the state know by tomorrow, if not earlier. Thank you,
Good.
Your Honor.
Thank you.
Good to see you,
Good to see you guys. Thank you. Alrighty, let's go ahead and bring in Mr. LeVay. You went back up? Alright, Lisette,
Yes, Judge.
for Ms. Frazier on page 3, did we get the bondsman information back?
Nothing yet. They've been trying to reach her and they can't.
What, I'm sorry?
They've been trying to reach her, but they're not able to.
Alright, so this is what we're gonna do. On page 3, we're gonna issue an arrest warrant for Ms. Frazier. We'll keep that 9/22 court date. Go ahead and street the bond, please.
Finish the bond, Judge?
I think I have to. Right?
Thank you.
You don't think so?
No, I think so.
Yeah, street the bond, issue the arrest warrant. I guess I'll get it from you later on tonight, right, guys? We'll just keep that we'll keep that 9/22 arraignment date. Maybe she surfaces and then can take care of it on that day if she comes to court. Or if it's a no action, I can always quash the arrest warrant. That's what I'm thinking. Yes. All right, let's go off record while we wait for Mr. LeVay. No. Bye.